Another important landmark judgment delivered by the apex court in recent months is relating to Competition Commission of India versus Schott Glass India Private Limited, where exactly the case revolves around abuse of dominance and as relating to the very provisions under Section 4 of the Competition Act of 2002 against the Act. The Competition Commission of India and the Competition Appellate Tribunal, the decision referred and ultimately went to the Supreme Court the very facts relating to Schott Glass and Schott Kaish and Kapoor Glass that we would like to discuss regarding abuse of dominant position and the very decision by Competition Commission of India than the decision delivered by the Competition Appellate Tribunal. So these are the very facts of the case, and exactly if you go to the very beginning of the facts of this landmark judgment that on 13 May 2025, a Supreme Court of India passed its judgment in the matter of Competition Commission of India versus Schott Glass, bringing an end to the 15-year-old litigation between Schott Glass and Kapoor Glass in relation to the alleged abuse of dominant position by the farmer. So the Schott Glass was a manufacturer of neutral USB-1 borosilicate glass tubing which is used to manufacture pharmaceutical containers such as ampoules, vials, cartridges, and syringes. Kapoor Glass was one such manufacturer of the pharmaceutical containers and procured borosilicate glass tubing from Schott Glass. Kapoor Glass was aggrieved because the additional rebates provided by Schott Glass to another group company of the Schott Glass, that is Schott Kaish, a competitor of Kapoor Glass, amount to discriminatory pricing and margin squeeze. The requirement to not process Chinese tubing imposed by Schott Glass as a precondition for availing functional discount and termed it unfair. Rebates being conditional on achieving the purchase quantity of two different variants of borosilicate glass tubing amounted to tying in. So the proceedings before the Competition Commission of India, based on a complaint from Kapoor Glass in 2010, the Competition Commission of India directed the Director General of Competition Commission of India to investigate, and based on the investigation report found Schott Glass guilty of abuse of dominant position. Accordingly, the Competition Commission of India imposed a penalty of 56.6 million rupees along with cease and desist order. Schott Glass challenged the Competition Commission of India's order before the erstwhile Competition Appellate Tribunal, which reversed the findings of the Competition Commission of India and imposed the cost of arrest 1 lakh on Kapoor Glass. So, in this context, we would like to go the very issues those issues which relates to this very important leading case, and there are six number issues raised, and those six number of issues that raised in Supreme Court. And to finally would like to discuss the issues in one by one. So the first issue raised regarding contravention of the provisions of section 4, subsection 2A and D, and in particularly as the very issue raised whether the target discount scheme of Scott India amounts to discriminatory or exclusionary pricing, and is it in contravention of the provisions of section 4, subsection 2A and section 4, subsection 2A, B of the Act, where the apex court held that the slab target rebate scheme employs a neutral, volume-based criterion applicable to all purchases alike, and is objectively justified by demonstrable efficiency consideration and has not been shown to restrict rival output, limit imports or distort downstream prices. And the second issue raised regarding target discount. So, whether the functional discount scheme imposes unfair or discriminatory conditions under Section 4.2a and Section 4, subsection 2b of the Act, where the court observed that every converter prepared to assume the same traceability and quality promotion obligations received exactly the same economic consideration. The ancillary conditions are objectively justified, and the evidence shows no foreclosure of rivals or suppression of output. The functional rebate and its successor agreements, therefore, do not offend either the provisions under Section 4, subsection 2a or Section 4, subsection 2b of the Act. And the third major issue raised regarding functional discount, and in particularly whether the Schott Kaish produced a margin squeezed prescribed as under Section 4, subsection 2e of the Act, where the court held that the long-term topping supply agreement does not contravene Section 4, subsection 2e of the Act, and the finding of Competition Commission of India on this head cannot be sustained. And the fourth major issue raised regarding the question relating to Section 4.2, subsection E and Section 4, subsection 2d, and in particularly whether Scott India Trade or Bundle NGA and NGC tubes, thereby breaching the provisions of Section 4, subsection 2d, where it was held that the essential elements of Section 4, subsection 2d of the Act are not proved, as NGA and NGC are not independent products. Converters were never compelled to buy both. No foreclosure was demonstrated, and in any event, the rebate design is objectively justified. The finding of tying cannot therefore stand, and so this issue is answered in the negative, as the court explained. Then we will go to the fifth issue raised regarding corporate and breach of natural justice. So, the fifth issue that whether an effect-based harm analysis is an essential component of an inquiry under Section 4 of the Act, and if so, whether it was omitted in this case. The apex court elucidated that Section 4 of the Act contemplates two logically separate findings. The first one, that the impugned practice falls within one of the descriptive clauses, such as Clause A and Clause E of the subsection, and that is subsection 2 of Section 4. And secondly, that it results in or is like to result in an appreciable adverse effect on competition. So, regarding that, the court therefore held an effect-based analysis is an obligatory component of every inquiry under Section 4 of the Act. Secondly, the Competition Commission of India, having relied on untested statements and pre-2009 correspondence, undertook no credible assessment of harm, and the third answer and the final answer provided by the apex court on the evidence marshalled by the Competition Appellate Tribunal, converter growth, stable downstream prices, absence of foreclosure, no appreciable adverse effect on competition is shown. So the very omission of a proper harm analysis vitiates the Competition Commission of India's order in layman, because each of the alleged abuses has already been negated on the facts. The appeals must fall on this additional ground as well. The Competition Appellate Tribunal's decision to set aside the Competition Commission of India's directions and penalties therefore warrants affirmation. So the issue raised here is answered in the affirmative with respect to both the questions raised in this issue, and the last issue relates to whether the investigation and the commission's orders are vitiated by denial of cross-examination, and whether it is breaches of natural justice, where the court said that the proceedings before the Director General and the Competition Commission of India were procedurally defective in a manner that by itself could have warranted dismissal of the complaint at the threshold. So the apex court, by electing to proceed on untested assertions, the Competition Commission of India deprived itself of the material needed for a legally sustainable finding and placed the respondent under an evidentiary handicap contrary to natural justice. So, the last issue, that is issue number 6, is answered in the affirmative as stated. So, now we will examine what exactly the judgment delivered by the apex court in this important leading case relating to abuse of dominant position as provided under the Competition Commission Act or the Competition Act of 2002. So the very judgment relates to volume discounts and margin squeeze than the decision cited of the European Court of Justice on British Airways decided in the year 2007, then functional discounts and tying in, and finally the very conclusion. So, both the Competition Commission of India and Kapoor Glass appealed against the Competition Appellate Tribunal's decision to the Supreme Court. The Supreme Court has dismissed the appeal. The key takeaways of the judgment as relating to volume discounts and margin squeeze while relying on the judgment of the European Court of Justice in British Airways case in 2007, the Supreme Court held that while dominant bonds must not favor or disfavor trading partners, applying different prices only becomes abusive only when it lacks an objective commercial justification or when equivalent customers cannot obtain the same terms. The court observed that since all the manufacturers of pharmaceutical containers were informed of the rebate ladder, which is the thresholds of sales volume to be achieved for availing a particular discount in advance, and no hidden concession existed outside the rebate ladder. Volume discounts to Schott Kaish cannot be considered abusive. Further, the apex court also did not consider the rebate to Schott Kaish, leading to a margin squeeze since Schott Glass was found to be absent in the downstream market. The rivals were able to operate with sustainable margins, and the market exhibited neither exit nor price elevation on account of the volume discounts. And as regarding functional discounts, the apex court held that functional discounts which were premised on performing certain functions were also not discriminatory since these restrictions applied uniformly to all the players. So the court held that the conditions imposed by Schott Glass were objectively connected with the legitimate aim, patent safety and brand integrity. And regarding answering the very question tying in, the court rejected the contention that Schott Glass indulged in tying in since the two variants were alternative specifications of one input rather than as independent products. So accordingly, the Supreme Court upheld the Competition Appellate Tribunal's order and imposed costs on Kapoor Glass for prolonging the litigation. One of the salient features of the judgment is also the court's finding that the investigation and the final order were vitiated since Schott Glass was denied the opportunity to cross-examine the witnesses whose testimony was relied upon to reach the findings of contravention. On a separate note, the judgment also lays down the principle for assessment of cases of abuse of dominant position. The court has clarified an effect-based assessment is necessary. Accordingly, in the absence of visible and substantial harm, an allegation of abuse of dominant position will not sustain, even if the conduct falls within the categories of abuse conducts listed as under Section 4 of the Competition Act 2002. So now we would like to conclude the very discussion and the lecture on this very important landmark judgment of the apex court relating to Competition Commission of India versus Schott Glass India Pvt. Ltd. So the very judgment delivered by the Supreme Court addresses the three critical issues. One is whether volume-based discounts violate the abuse of dominance position as provided under the Competition Act of 2002, subsequently amended, whether cross-examination is warranted during the Competition Commission of India's adjudicatory process, and the third central issue is concerned whether an effect-based approach is essential in cases involving abuse of dominance position. So, regarding the first issue, the Supreme Court held that volume-based discounting does not amount to abuse of dominance as long as the discounting policy is neutral, objective, and uniformly applicable to all customers and devoid of foreclosure effects. In such cases, there is no unequal treatment of equivalent transactions, and therefore allegations of discrimination are unsustainable. And regarding the very second issue, the apex court observed that cross-examination is warranted when the findings of infringement rest significantly on witness testimony, where such testimony forms the evidentiary basis of the decision, particularly when the deponents are adverse to the defendants. The right to cross-examine becomes critical to test the credibility and veracity of the evidence presented. And on the final issue, this apex court underscored the necessity of adopting an effect-based approach in abuse of dominance cases. This interpretation was grounded in the preamble of the Act itself, as under Section 19, Subsection 3 and Section 19, Subsection 4 of the Constitutional Doctrine of Proportionality. The adoption of this standard raises the evidentiary bar for the Commission, requiring it to establish concrete demonstrable effects of the conduct on competition. Consequently, the Competition Commission of India's investigative burden is likely to increase at which it may require detailed and time-consuming market studies, potentially prolonging the duration of investigations. This may have a cascading effect on the investigations in the tech sector, which are currently underway. The Director General of the Competition Commission of India will now be required to conduct market surveys, interview a wide range of stakeholders, the end consumers, competitors, ancillary service providers, etc., before reaching its conclusion. So, these are the final judgments regarding those issues raised in this important landmark judgment that we would like to complete here this lecture relating to the findings of the apex court in regards to this landmark judgment on Competition Commission of India versus Schott Glass India Pvt. Ltd.